Good afternoon. Um, when you talk about long-term care planning, lots of areas of the law come together to affect the situation. First, you have surrogate decision-making, how a decision is going to be made when your family member becomes unable to make them themselves. There's a topic that's addressed just to that, so I'll touch upon it, and then I'll trust that the later speaker will go into more detail. You have to know a lot about taxes, both death taxes, inheritance or estate, income taxes, transfer realty tax, personal property tax. Lots of tax issues come up when you deal with planning. Then you have all of the entitlement issues, Medicare, Medicaid. Then you have insurance issues, whether it's your major medical insurance, your long-term care insurance. Then you have the traditional estate planning concepts that you don't want to do planning for long-term care to accomplish one result if it's going to be contrary to the result that would occur under traditional estate planning. So when all of these things come together, I tell my clients and/or when I'm speaking that little differences in one situation can make a big difference in the planning. Whether you're planning for one spouse planning for another, could be entirely different than a child planning for a parent or a sibling planning for another sibling. So little things make a big difference, and although I hope to alert you to a lot of the different issues that may arise, it is no substitute for going to a lawyer or some other financial planner who's knowledgeable about these things so that they can review your own situation and then give you advice that's tailored to your situation. In previous years I've spoken, I was usually the last one, and I could tell when I'm losing people when their eyes start rolling in the back of their head because it was late in the day and we're talking about some of these topics, but I'm not so sure that it'll make that much of a difference that I'm a couple hours earlier. So what I'd first like to talk about is surrogate decision making. How are you going to make decisions if your family member becomes unable themselves? There are really two kinds of mechanisms by which you can make these decisions. One is a voluntary mechanism, one is an involuntary mechanism. So that if you haven't planned it all, or if you haven't planned fully or completely, then you may not have a choice but to utilize an involuntary mechanism, which is called guardianship. Guardianship, it used to be in Pennsylvania, and a lot of this topic is based on state law. So if you're from New Jersey or Delaware or New York, it could be slightly different. There are also federal law that comes into play, which is solely federal law, as well as federal and state joint programs like Medicaid. So under Pennsylvania law, when you have guardianship issues, it used to be that a person was either incompetent or they were competent without recognizing the degree of incapacity. And a number of years ago, Pennsylvania changed the law so that you can have a limited guardianship, or if someone is completely incapacitated, a plenary guardianship. Then you have guardian of the person as well as guardian of the estate. Sometimes you can go for just guardian of the estate and not go for guardianship of the person because your family member may have lost their ability to make financial decisions, their executive functioning may be off, but they could possibly still know the difference if someone says, well, you have cancer. They may be able to decide, well, I don't want to be treated, or I want to be treated aggressively. So basically, a guardianship now under Pennsylvania law is graduated, and it is geared to trying to take into account that there are different levels of incapacity. My preference is to avoid guardianship for many different reasons. The first reason is that it is very expensive. You have to hire a lawyer. We know what lawyers charge. You then have to hire a doctor to get an evaluation. You then have to file papers in court. You then have to have your family member be brought into court. Prior to having them brought into court, you have to serve a citation upon them, which is a recitation of all the reasons why they're incapacitated, and it has to be personally read to the alleged incapacitated person. And when they appear in court, whether they remember the incident a half hour later or an hour later or not at all, when you're in court and you hear the doctor talk about how the deficits that the individual has, many people, even with a significant dementia, understand that they're being told that they just can't cut it anymore. So it's important, if I can, to avoid it. And what I try to do is I try to do anything to avoid it. You know, if I can have an informal system, a support system, such as someone coming over and writing out checks with the incapacitated person, and because they refuse to sign a power of attorney or something like that, hoping that down the line the person would sign a power of attorney. The only thing that is good about guardianship is sometimes that it is involuntary, meaning that if your family member's at home and not safe, they've left the stove on many times, yet they refuse to relocate to an assisted living center or something like that, then you go into court and you file the papers. And if you get them adjudicated incapacitated, they don't have a say any longer in what's going on. As a matter of fact, they can't vote, they can't enter into a contract, they can't get married, they can't do anything. All of that authority is essentially transferred to the judge, and the judge oversees everything and in essence tells the guardian of the person or the guardian of the estate what decisions can be made. So we're going to talk about some healthcare financing issues, but if a person has been adjudicated incapacitated, you're not going to be able to do that because judges don't want to hear about Medicaid planning to try to preserve assets so that the state takes over and pays sooner than otherwise. So I try to avoid guardianship, but if a person is really uncooperative or if there's a battle between two siblings, each who have a power of attorney, they keep on taking mom out to lunch and stopping at the lawyer's office and then having the power of attorney drawn up. I'm not going to go battle that. I'm just going to go right into court and I'm going to say, hey, this person has 4 powers of attorney in the space of 6 weeks, obviously doesn't know what they're doing, have the court decide who should be the decision maker. So guardianship can be good under some circumstances. The most common voluntary arrangement is a power of attorney. Power of attorney is a simple document between 2 individuals. The first is the principal, usually the person who is incapacitated or is at least beginning to show signs of deficits, and then they make a contract, in essence, with the agent under the power of attorney, the designated individual who will make those decisions. And the decisions that the principal authorizes the agent to make is set forth in that document. And if you have a properly drafted document, it could be anywhere from 3 to 5 pages long with 25 paragraphs, some having 5 subparts. And it's not unusual for some people to say to me, oh my God, what is this? You know, I'm never going to use that. And the answer is there may be some provisions that you won't use in a power of attorney, but if it isn't in the power of attorney and by some chance, you know, that circumstances come up that it would have been a good idea if it was in the power of attorney, you may not be able to, at that time, execute a new one because the person may have lost capacity. So in order to do a power of attorney, the person must have the ability to understand it. They can have a dementia, they can be forgetful, but they need to know, A, who the person is that they want to give this authority. They have to know what authority that they're giving. You know, I say, you understand that your wife is taking care of your finances? Yes. Is that okay? Yes. This document will make it easier for her to make those decisions. Is that okay? If they understand all of that, then the person generally will have capacity. They may not understand every paragraph in there, but they don't have to. They understood that this power of attorney would be helpful to them. If in fact you don't have power of attorney and you're not willing to go for adjudication of incapacity, Pennsylvania recently passed a Healthcare Representative Act such that there is a priority of individuals who can make decisions for medical care. However, a lot of providers don't feel very comfortable with that, and they'll say, sorry, I can't talk to you. I'm not going to authorize this procedure. I just had a dentist who, for a mentally challenged individual, needed to have dental work done, needed to have anesthesia because he just would not tolerate any kind of work being done. So the dentist said, no one has power of attorney. I'm not going to do anything until you get a guardianship, a decree that basically says that you're in charge and you can make those decisions. So decision making is very, very important for any of us, because who's to say we walk outside, get hit by a bus? You know, I'm 57. If I'm incapacitated, my wife has to be able to make decisions for me. Just because she's my wife doesn't mean that legally, technically, she's authorized to make decisions for me. Many times it's a very practical thing for the closest family member to make decisions. Obviously, who else are they going to ask for if the patient is really demented? But technically, they don't have to, because they have something that's called HIPAA, the health privacy laws, that could that physicians or other healthcare providers can stand behind and say, I'm sorry, I can't disclose the information. So if nothing else, that you take away nothing else from my presentation, it's the importance to address this issue, because it will hit you right in the face at some time if you don't. So that's surrogate decision making. So the next question is, how are you going to pay for health care? And that's difficult, and it gets harder all the time because the laws change all the time. But what I like to focus on is that there are 3 levels of care: skilled, intermediate, and custodial. Skilled care, what is that? That's the kind of care if you fall and break a hip and you go into the hospital, that's skilled care. Have a stroke, you're in there till getting stabilized, and with all the doctors and everything else, that is skilled care. Skilled care is usually not that hard to deal with, because most people over the age of 65 have Medicare, which is the health insurance law, but Medicare is not enough because there's lots of copays, there's lots of deductibles. So usually if you have Medicare, then you need a supplemental health insurance policy. Sometimes that's called a Medigap policy. And if you don't have it, you can be looking at significant bills, even though Medicare may pay for a majority of that. Nowadays, they have managed Medicare policies where you're totally disenrolled from Medicare, and then the insurance company, whether it's Aetna or Blue Cross, you are enrolled and you're in their HMO. My feeling is that as you get older, you need more flexibility to deal with the issues that arise more commonly. Then's not the time. At this time, it's not really the time to have a managed Medicare policy. I much prefer traditional Medicare and a traditional supplemental. If you're directly discharged from a 3-day hospital stay and you're directly discharged to a skilled nursing facility, such as for rehab, then Medicare will pay in full for the first 20 days, and then for day 21 to day 100, there's a deductible of $140 a day. Usually the supplemental picks that up, and then between the two, they pay from day 21 to day 100. Most people think, okay, I'm getting my mother fell, broke a hip, needs rehab, is going from the hospital into the rehab facility. That's skilled care. I got 100 days to make decisions. Well, you don't, because Medicare and the supplemental or major medical, which is kind of the equivalent to Medicare and a supplemental, they say that you have to be making improvements. You have to basically continue to benefit from that care, or you cannot have reached your rehabilitative potential, or that you cannot have plateaued. Because if you're not getting better, then the insurance company says, we're not paying for that. And especially with individuals who have a dementia, if they fall and break a hip, they go to rehab, they may not really remember what they're being taught. So it's not uncommon that for a person who has dementia, after a week or after 2 weeks, the nursing facility says, come Wednesday, you're going to be private pay. So either you start paying privately or you take your family member out. So people who think that just having Medicare and the supplemental can help with this situation will find out that it doesn't. At the other range of care is what's called custodial care or personal care or assisted care, which is what the kind of care you get at an assisted living facility. No one pays for that in Pennsylvania, except out of your own pocket or unless you have a long-term care policy. So basically, a word about long-term care insurance. My feeling is first of all, it's not like getting a auto insurance when you have a bad driving record. If you've already been diagnosed with a dementia, you become uninsurable. No one will basically grant that to you. So the earlier you do it, you're guaranteeing a policy that will cover this kind of experience, this kind of care. And as you grow older, the premiums get more expensive, or you could become uninsurable. When you get a long-term care policy, there are many different aspects to it. How much per day, what the elimination period is, meaning how much time between when you go into the facility and when the policy begins to cover. How much is it going to pay per day? How long does it last? 2 years, 3 years, 5 years, lifetime. I generally don't recommend lifetime because after 5 years, not that many people remain in institutional care for that long a period of time. My experience is that having long-term care insurance gives you more flexibility. A policy should have at home, for an assisted living facility, and also for a nursing home. If you have that, you have more choices. You have more flexibility. You have the ability to kind of plan so that you want to take care of the person at home for a while they're still higher functioning. You can do that. At-home care can cost, $3,000 to $5,000 a month. Assisted living can cost anywhere from $4,000 to $7,000. Nursing homes cost anywhere from $7,000 to $10,000 a month. So having a policy that picks up for that, sometimes in full, if you have enough of a per diem, or at least partially, allows you to make other decisions. So long-term care insurance is important. You can't get it once you have the dementia. As early as possible, you should get it. I used to think that, I'll wait until I'm 60 years of age and then I'll get long-term care insurance because I'll cancel my disability insurance. And so because disability only really will cover for a couple of years afterward, I'll get the long-term care then. I had a friend who came to me who was breaking into the business of selling long-term care insurance, and he started showing me that the difference between premiums at the age of 50 versus the age of 60 was really, really significant. So I said, you know what? I pay a lot of money for taxes and insurance. What's another insurance policy? So we got that for my wife and I. Having insurance is important, long-term care, if you can get it. It's not inexpensive. A lot of people can't. Sometimes you have enough resources that you don't need it. You can self-insure. But if you don't, having the policy is good. In between skilled care and custodial care is intermediate care. That's the type of care that a person generally gets in a nursing home. And if a person needs that kind of care, and most individuals who have a dementia, progressive dementia like FTD or Alzheimer's, they will need that kind of care, whether or not you have someone living in it 24 hours a day, 7 days a week. That could be equivalent to being in a nursing home. Most people with this dementing disease will need that kind of care. So if you need that kind of care, and if 3 other criteria are met, then medical assistance or Medicaid, some people, even lawyers, mix up Medicaid with Medicare. Medicaid will pay for those charges. So the right level of care, you must be at a Medicaid certified facility. Not all nursing homes are Medicaid certified, most are. Those that aren't don't make them better, and those that are don't make doesn't mean that they're worse. Really, there are some facilities that are not Medicaid certified that I wouldn't put a dog in, and there are other Medicaid certified facilities you can eat off the floor. So what you have to do is you have to be a good consumer. You have to go in. You go in at 11 o'clock in the morning. Are people still in their night clothes? Do you do the sniff test? I mean, are you hit by the smell of urine? You look at the activities. You go at off hours to see what the staffing is, and that's how you select. The most important criteria, in my opinion, is having the person close by, because if you visit every day, my belief is that you're going to have better care for your family member. And just as an example, if there are 2 people in a room, they both soiled themselves, and one never gets visitors, and the other one gets visitors every day, sometimes twice and 3 times a day, and then you have an aide who comes in, who they're going to change first. They'll probably change the one who gets the visitor, because God forbid if they don't, even if the person was like that for 5 minutes, they can come in and say, how long has my mother been this way? Please get to her. While the other person who doesn't have anyone, well, they don't have anyone to advocate for you. So basically having the person close, in my opinion, and visiting is very important. So, right level of care, Medicaid certified facility, the person's income must be less than the cost of care, which is pretty easy. Nursing homes cost $7,000 to $10,000 a month. Not too many people have fixed income that way. And then you can't have available resources, because that's a term of art, and it includes some things, it excludes other things. So, and this is where, if you're planning for a husband and a wife, it's much different than if you're planning for example, a parent and a child. Because when you have a husband and a wife, then basically they look at the husband's assets, they look at the wife's assets, they look at joint assets. If they're not exempt, they look at all of them. Whereas if you have a parent and a child, we're just looking at the parent's assets. So the situation where you just have an individual and a child taking care of them, the parent can have, if their income is less than $2,000 or $2,100, then figure just went up, $2,100 a month, they can keep $8,000 in a cash account for their miscellaneous needs. If their income is above $2,000 a month, then they can only keep $2,400. In addition, they can have an irrevocable burial reserve account, meaning if you're going to be spending lots of money on a nursing home, this state allows you to prearrange and prepay for the funeral. And whatever you put in, although you can't get it back out, you also aren't required to use that for that care. You can do it either by going to a funeral home and prearranging and then prepaying, or you can just go to a bank and open up an irrevocable burial reserve account. If you do it that way, person passes away, you make your funeral arrangements, get the bill, get the death certificate, go to the bank closes out the account, makes the proceeds in a check payable to the funeral director. My feeling is I'd rather prearrange and prepay so you know exactly how much you're doing. Just the other day, I was having an issue in terms of Medicaid, and the council told me $10,000 for a casket, forget it. That's outrageous. And usually I argue with them all the time, but in this situation, I kind of agreed because the funeral was almost $15,000 because we had a $10,000 casket. But in any event, you can prearrange and prepay for the burial, and in that situation, you are are protected so that when your family member passes away, you don't have to come up with fresh dollars. So that's what the individual in a nursing home can have. The spouse at home, there are some protected assets. The house in which you reside, as long as the house is less than $500,000, in most states, Pennsylvania, it's $750,000, then none of the equity is counted at all. So no one will make you sell your house to pay for the care of your family member in the nursing home. However, if it's jointly titled and then the community spouse, just like Gary said, sometimes they don't take care of themselves, they kill themselves taking care of their partner. If the house was in joint names, although the house for the community spouse isn't required to be sold to pay for the institutionalized spouse, if the community spouse died first and the institutionalized spouse owns the home, then either they will put a lien against it if you choose to hold on to it, or they'll make you sell it right up front. So a lot of times we suggest transferring the house from both names into the community spouse's name. That is an exempt transfer. Transfers that aren't exempt have penalties to it. I'll talk about that in a second. Also, an IRA, a qualified retirement account, is also exempt, that is owned by the community spouse. It is not, if the institutionalized spouse owns the IRA, it's counted, you have to use it. If it's owned by the community spouse, then it's exempt. I just had someone come to me, they had $500,000 in their IRA, their spouse had Alzheimer's, and they owned the home. You know, as soon as the individual with Alzheimer's goes into the nursing home, day one eligible, even though spouse at home who has $500,000 in the retirement account, that retirement account is exempt. Very important. If you have the IRA for the institutionalized spouse, keep in mind that when you're paying for care in a nursing home or assisted living, that is a medical expense deduction on one's income tax return. So for example, if you're looking for a source to how to pay for the nursing home care, then if it costs $9,000 a month, then the institutionalized individual, you contact their IRA custodian and you say, I need $8,000 a month. Whenever the $8,000 comes out of the IRA, it is taxable for income. As soon as you pay it for the nursing home charges, it is deductible. So it's a wash, and the government, in essence, helps you pay a little bit. The last asset that is generally exempt is that the community spouse can keep half of all of the assets so long as it doesn't exceed a certain limit, and that is $113,650. So if you have $100,000, community spouse keeps half, institutionalized spouse keeps half. If you have $226,000, half and half. If you have $400,000, community spouse can still only keep $113,000. Lastly, penalties. If you give money away, if you have money on day one and you put your spouse in the nursing home on day two, if on day three you give money away and on day four you apply for medical assistance, the government's going to say, hey, you just gave money away. So giving money away creates a period of ineligibility. The maximum period of ineligibility is 5 years. So if you plan early and you do various things that can be done 5 years in advance and then apply for medical assistance, then whatever you've done in advance, if you've done it correctly, will not be counted. Unfortunately, if you give money away, then you're giving up control. And even with good kids, sometimes bad things happen to good kids. They could pass away. Your money, if you gave it to them, could be tied up in probate proceedings. They can get divorced. Your money, the spouse, your ex-daughter-in-law can say, hey, I own half of everything you own. You have mom's money. I own half of that. That's what happens. So a lot of times we recommend trusts. Trusts have their own advantages and disadvantages, but really for a half hour, that's all I can basically talk about. So thank you very much.